Kia ora, hello everyone. Thanks, Beth, for the introduction, and thanks again for sort of changing the program so I can present today. So I am going to talk about access to information for persons with disabilities as a catalyst for operationalizing their ESCRs in New Zealand, which is a bit of a mouthful. So to explain really what I mean by that, and I have to say, I mean, it's a bit of a cliche to say that, you do try to connect the dots in academic research and try to find nexus. And but that's really what I've been trying to do. It is a work in progress, however. So I'm only presenting, I guess, maybe half of the picture, and we'll have to wait and see if I'll be successful in connecting the dots between the right to information, accessibility, and the economic, social, and cultural rights of persons with disabilities. So a bit of background into the topic and what it means really. So last year I did some research for UNESCO on the place of disability rights in access to public information legislation specifically. So the scope of that research was somewhat more limited than what I'm trying to do with this paper. For that, basically what I did was looking at any countries in the world that has a access to information code or statute or law, either generally or in relation to public information specifically, and then looking at whether or not there are any references to the rights of persons with disabilities, and whether sort of provision of accessible information was included or mentioned in the access to information law. And I looked at sort of any references at all. And if there was something, I looked at what type of disabilities were covered, whether accessibility related to making of requests for access to information, as well as providing accessible information, were there any conditions imposed, issues of cost and time limits, or refusal for provision of information, and also if there were any sort of appeal and oversight mechanisms built into the Act, either generally or again in relation to providing access to persons with disabilities. So what I found, unsurprisingly, was that out of the 132 countries that have an access to information law, most of them don't include any references to persons with disabilities. So there were only 37 that did include an explicit reference to persons with disabilities. There were some that had a number of provisions that could be seen as being helpful or useful for persons with disabilities. For instance, in some cases, the law might mention that if requests for information are normally made in writing, but someone is unable to do that, they can be assisted by the information officer to make their request sort of verbally, for instance. But as I said, only a very limited number had provisions specifically for persons with disabilities. But again, that was not really surprising. What I did find, which was surprising to me, was that New Zealand was one of the countries where the access to information law does not mention persons with disabilities, because I know that accessibility and access to information is something that has been on the agenda for New Zealand government for quite some time. And I had previously looked at access to information from a different perspective, specifically in relation to access to information that is protected by copyright law. And there has been amendments to law recently in 2019 to amend the Copyright Act to improve access for persons with disabilities. But again, that related specifically to copyright protected information included in books and journals and so on. So once I did that, I decided to look into what was happening around access to information for persons with disabilities in New Zealand, and explain the existing legal framework around access to information, And disability, so I have mentioned the Official Information Act 1982, which is the piece of legislation I looked at for the research for UNESCO, which does not mention disability. And similarly, the Local Government Official Information and Meetings Act, which is sort of very similar to the Official Information Act, but specifically in relation to local government meetings and documents and so on. So neither of them mention disability. However, freedom of expression, including access to information, is of course mentioned in the New Zealand Bill of Rights Act 1990 and the Human Rights Act, which sort of complement the Bill of Rights Act, mentions disability as a prohibited ground of discrimination, which obviously then relates to the state's obligation for non-discrimination in relation to access to information. And just a little further on access to information for persons with disabilities. As I said, this has been an issue for quite some time in New Zealand. So the CRPD committee, which is the committee on the Convention on the Rights of Persons with Disabilities, has in its concluding observations on all the reports that New Zealand has submitted so far mentioned problems with accessibility of information for disabled persons in New Zealand. So in the first report, the committee specifically talked about sort of the limited number of New Zealand sign language interpreters. Sign language is widely used in New Zealand by the disabled community, and also specifically mentioning sort of the even more limited availability of interpreters that can speak Te Reo Māori or switch between English and Te Reo Māori. And this was raised again in the most recent round of reportings. And the committee mentioned gaps in the provision of government info specifically. Sort of outside of the legal framework, we also have some policy initiatives, most importantly, the New Zealand Web Accessibility Standards, which was based on the sort of global web content accessibility guidelines, which requires that all government websites that include information available to the public need to be accessible. And the Office of the Ombudsman, which is the body that has oversight over the Official Information Act and making of official information requests, has also been sort of gradually more active in relation to the provision of accessible information for disabled persons. For instance, in their 2020 proactive release guidelines, they talked about accessibility of information for persons with disabilities. I'll talk about the Ombudsman's office later on a little bit as well. And something else worth mentioning as well, just in terms of the existing legal framework, is the Accessibility for New Zealanders Bill, which was introduced this year after many years of sort of campaigning by the disability community and different civil society organizations, and the CRPD committee encouraging the government to adopt an accessibility sort of policy or standards and principles. It's been a bit of a bittersweet exercise watching the bill and sort of discussions around it. So it just closed for public submissions, and the select committee will issue its report early, I think, March next year. And there's a lot of criticism on the bill because it does not include any sort of compulsory or binding accessibility standards or principles. In essence, it only creates an advisory committee that would progressively sort of work on removing accessibility barriers, but doesn't have any kind of binding powers or any oversight powers and so on and so forth. So we'll see what happens with the accessibility bill. I'll come back to that as well. Now, so that was one of the, I guess, dots. And then moving on to the next one, as some of you may know already, New Zealand is a signatory of the covenant, obviously, but it hasn't signed the optional protocol. Economic, social, and cultural rights are also not incorporated into one piece of legislation in the same way that civil and political rights are, so they're not mentioned in the New Zealand Bill of Rights Act or the Human Rights Act. And a former New Zealand Prime Minister, Sir Geoffrey Palmer, has been a famous opponent of including economic, social, and cultural rights into the New Zealand Bill of Rights Act for some of the reasons that Malcolm mentioned in his great keynote earlier, mainly because Sir Geoffrey sees them as ideological sort of principles rather than justiciable rights, and also for issues of judicial incompetency in what he calls sort of dealing with complex policies with social and economic impact, which is quite an interesting view considering that the court's dealings with a lot of civil and political rights also have impacts on complex economic and social issues. For instance, if you think about sentencing or custody of children issues. But anyway, instead of being included in the Bill of Rights Act or any other one piece of legislation, the rights are, or rather different aspects of some of economic, social, and cultural rights are included in a range of different enactments. For example, the Minimum Wage Act, Employment Relations Act, Social Security Act, and so on. But in many cases, these don't necessarily provide absolute protection of economic, social, and cultural rights for persons with disabilities. For example, the minimum wage exemption still exists for disabled persons. Accessible housing is a big issue, accessible education, and so on. I'm conscious I'm sort of getting towards the end of my 15 minutes. I think what potentially could be the answer to all of that, sort of that legal legislative background and framework is sort of looking at the hybrid rights model under the Convention on the Rights of Persons with Disabilities. So, and in the absence of a sort of robust legal framework for protection and fulfillment of disabled persons' economic, social, and cultural rights, maybe under this, again, the hybrid model of the Convention on the Rights of Persons with Disabilities, the right to information, which is incorporated into the law in New Zealand, can provide some kind of answer for operationalizing economic, social, and cultural rights. And what I mean by the hybrid model of rights is that some of the rights in the convention sort of incorporate aspects of both civil and political and economic, social, and cultural rights. For instance, Article 9, probably most prominently, which is the article on accessibility, relates to states' obligations to provide accessible information, but also accessible housing and accessible infrastructure and accessible transport. So accessibility when it comes to all aspects of the physical and digital world. So if you put Article 9 together with Article 21 of the Convention, which is on freedom of expression, including access to information, we could maybe sort of form a puzzle that economic, social, and cultural rights could also fit into. And I thought a good way of sort of showcasing this would be by looking at some of the decisions of the CRPD committee. So in Gamma Beasley and Australia, some of you might already be familiar with one or more of these decisions. This case related to provision of, or rather the lack of provision of Australian Sign Language interpretation for jury service. And the court found that this the failure to do that was a violation of Article 9 with regards to accessibility, but also Article 21 in relation to freedom of expression. So again, we see the marriage of the two rights. And in Fiona Given and Australia, which related to right to accessible voting, again, the failure to provide the author with an accessible mode of voting, which also protected her privacy, that also breached Article 9 of the Convention regarding accessibility. So again, we see that the umbrella of accessibility under the Convention is quite large one, and it could give effect to other rights, including economic, social, and cultural rights, although in these cases, they related to civil and political rights. But again, this might be something where in the future, this would be extended to economic, social, and cultural rights as well. Now, in New Zealand, what we've seen so far is a lack of, obviously, the lack of domestic protection, but also a lack of willingness from the courts to sort of recognize such a hybrid model. So far, they've been very strict in terms of distinguishing between what's been incorporated and what's not in the Act, or sort of the New Zealand Bill of Rights Act or the Human Rights Act or any other domestic legislation that incorporates economic, social, and cultural rights. But I it's sort of hazarding a guess, and I guess this is the part of the paper I would need to sort of do more research on and write, is whether the coming into effect of the Accessibility for New Zealanders bill in its current form or potentially in a changed format would make any difference to the approach of the courts in using that implied model of rights that, again, I think Malcolm was talking about, in sort of implying a lot of economic, social, and cultural rights into the state's obligations under non-discrimination and accessibility, and again, giving effect to them indirectly. And also what I want to investigate is other avenues, for instance, under the jurisdiction of the New Zealand Human Rights Commission and the Human Rights Review Tribunal, and what the Office of the Ombudsman has done so far in terms of protecting equality in access to official information. And the CRPD committee has not considered any complaints from New Zealand yet. It has the jurisdiction, it has had that since 2016, but there hasn't been any cases before the committee from New Zealand yet, but maybe in the future that could be another, again, especially if the accessibility bill is passed, that could be another option for operationalizing economic, social, and cultural rights in New Zealand without necessarily incorporating them into legislation. And that's the end of my presentation. Thank you all.
Thank you.